Right, do we have everyone assembled? Good morning, Officer
No.
Tucker. Do you have the appellant, Ms. Burgess, there?
Yes, I do. I can bring it in.
Thank you.
Sorry, I think I'm in the wrong.
No, you're not, Mr. Robinson. We
Oh,
have
I
a
see.
judgment handing down before we.
I'm sorry.
Ms. Mulligan, could you confirm if you're holding for Mr. Richardson?
I can hold for Mr. Richardson. I did speak with him yesterday, so
Okay, thank you.
good morning.
Good morning. Right, the Court of Appeal is now assembled in Bermuda for the handing down of judgment in case numbers 2 and 5, criminal appeals. That is Katrina Burgess and Cleveland Rogers against Her Majesty the Queen. Ms. Mulligan is appearing on behalf of appellant Mr. Rogers and holding for Mr. Charles Richardson, who appears for appellant Ms. Burgess. This matter has been listed for handing down of judgment. My Lord President.
For the reasons contained in the judgment which I now hand down, both these appeals are dismissed.
Much your pleasure.
Thank you.
Thank you. The judgment has been circulated by email, so it should be with you now, if not shortly. That concludes the business for the Burgess and Rogers appeal. So if you could remove yourselves from the meeting room. The next matter on the docket is Civil Appeal number 6 of 2021. Jamie Shea Tang against Sinopoly Strategic Investment Limited and another. Ms. Leela Zul of Zul & Co. appears on behalf of the applicant. Mr. Keith Robinson and Mr. Kyle Masters, who I don't see present, of Carrie Olson appear on behalf of the respondents. This matter is taken before my lords and ladies, Sir Christopher Clark, the president, and Justices of Appeal, Jeffrey Bell and Dame Elizabeth Gloucester.
Right. Well, good morning to you. Thank you very much for the chronology and the dramatis personae, which I, speaking for myself, have found particularly helpful, given the fact that there are quite a number of different companies, some with similar names, and because it's quite an effort to work out which company is in receivership or liquidation and where at any one time. So those documents have been very helpful. Less helpful is the fact that we don't seem to have any core bundle for the purposes of the application before us. And I think we have assembled amongst ourselves most of the relevant documents, but I'm not 100% convinced that that is so. I'm afraid as a result of the way in which matters have progressed, I have rather a large number of questions which I need to have answers to in order that we can begin to make a decision. So, Ms. Huell, if you'll forgive me asking you questions at the beginning rather than listening to your submissions at the beginning, that's what I propose to do. We are dealing with, as I understand it, the application made by Mr. Che and Mr. Tang. Mr. Che having been a director of Sinopoly and Union Grace until he was removed by the liquidators of FDG Electric, and he was the chief executive officer and a director of Kinetic. Have I got that right? Monsieur, you're muted.
My apologies, my lord. I was on mute. I did respond. I said, yes, that is correct.
I thought you said that, but right. Mr. Tan is one of the receivers of Kinetic, as I will call them, who was appointed in April 2020.
Yes, yes, he is one of the receivers.
Now, the first order question is whether what we are concerned with is leave to appeal on the part of the joinder respondents, or simply directions for the hearing of the appeal. The appellants, Mr. Che and Mr. Hua, have they in fact been joined as respondents below? Presumably they were at some stage.
No, my lord, they have not yet been
They have
joined.
not. They've
No.
not been joined. Oh, okay. Right. And you sought leave to appeal below, and your notice of motion is for leave to appeal here before us. Are you saying that you don't actually need that which you asked for below and asked for above?
My lord, the notice of motion that was filed below, well, the application for leave was heard and denied. There was a second application for leave in respect of the proxy orders filed below, and that has not yet been issued for hearing.
But
When was
I'm
that?
sorry. We're not concerned with the proxy orders, are we?
Well, the application for leave has not yet been heard by the Supreme Court, so it's not before this court at this stage.
Well, forget about the proxy orders then. What we are concerned with is the orders made on the 1st and the 29th of April, for which, as I understand it, tell me if I'm wrong, you sought leave from Mr. Justice Mussenden, but were refused, and filed a notice of motion for leave to this court to appeal.
Yes, my lord.
Now, that would appear to be predicated on the basis that you need leave. Do you accept that you need leave or
No,
not?
my lord. No, my lord. My client's position is that leave is not required. The reason that we did make the application for leave was that the position taken by the respondents was unclear. The respondents at various places in both their evidence and in their submissions seemed to indicate that leave was required and that leave was not required. So in order to preserve the client's position, we made an application for leave to appeal, but our position is that leave is not required.
And why is it not required, given that the order was made at an interlocutory hearing and the petition has been stood over sine die for hearing? Why are we not dealing with interlocutory order?
My lord, the order was final and binding.
Sorry, which order is that?
This is the order for 1st of April. I believe that's what we're referring to. So the 1st of April order made a final and binding, was final and binding in nature. And it is my understanding, based on both the skeleton argument and the evidence, that the respondents accepted that position. What was left to be dealt with was costs. So it was a discrete point that was left to be dealt with under the petition. So the relief under the petition had already been granted, save for the respondents being able to come back on the issue of costs.
Right.
And that is what was adjourned sine die.
I see. Okay. Right. Well, we'll hear Mr. Robinson on that in a moment. Right. Now, next item on the program, the company, Kinetic, has not appealed. In those circumstances, what interest do your clients have in an appeal in circumstances where, so far as one can see, they were only affected by clause 4 of the order of the 1st of April, that Mr. Chi should be chairman of the meeting. 7, that he should have no discretion to ignore the votes of the majority shareholders. And 10, that the current board should take all steps necessary to permit and no steps to impede the directors elected at the adjourned AGM. I mean, that is all over and done with, isn't it?
My lord, the company is not bringing the appeal, and
Yeah.
I only act for Mr. Chi and Mr. Tang.
Yes.
But the directors, of course, we would submit in the course of meeting their obligations and in the course of conducting the AGM. So Mr. Chi, both as the director and chairman, is bound by the bylaws of the company. And we submit that the bylaws of the company, albeit that we don't act for the company, the bylaws of the company, the effect of the April 1 order was, among other things, to amend the bylaws without the proper procedure having been followed.
Yes. But, right. Well, where we've got to at the moment is, as I understand it, that the company has been wound up by the court in Hong Kong, although it is a Bermudian company. Is that right?
That's correct, my lord.
And what is
winding up order?
Yes, yes. And what was the basis of the winding up order? Why was it wound up?
My lord, I don't immediately have an answer to that. I can come back to you on that if I may.
Well, was it a creditor's petition or a shareholder's petition?
I believe it was a creditor's petition.
Right. Okay. Let us assume for the moment, we can obviously find out, that it was a creditor's petition. Let us assume in your favor that the orders of the 1st of April and the 29th of April were invalid. Those orders deal with the holding of the annual general meeting and the elections of directors for Kinetic. Kinetic, as I understand it, is now subject to the liquidation, the liquidators having been appointed on the 6th of September. Is that right?
Yes, that's correct. But the appointment of the liquidators, so on the 7th of October at a meeting of creditors, there was the appointment of certain persons as liquidators in Hong Kong, but the powers of the receivers continue.
Well, wait a minute. Okay. So, well, you say the powers of the receiver continue, but the effect of that and the extent to which they continue may be debatable. The effect of that is that the company is now either under the control of the liquidators or the receivers or both. Why, in those circumstances, does it matter tuppence what did or didn't happen at the annual general meeting?
It matters, my lord, we submit, because if the directors of Sinopoly and Union Grace were not validly appointed, then the actions that they've taken will be void.
But those actions have been superseded by the liquidation in Hong Kong, have they not?
My lord, I can only go by my instructions, but my instructions are that the powers of the liquidators do not trump the powers of the receivers. And the receivers still are.
We're talking about the position of directors. You're not concerned with any dispute as between the liquidators and the receiver, are you?
No, my lord. I may have misunderstood your question.
Well, my question is this. The powers which the company, to control the company, which now exist, rest either with the liquidators or the receivers or both. I'm not really concerned what the correct answer to that is. What the powers of the company do not rest with whoever may have been or should have been a director before the liquidation.
My lord, I accept that.
Right. So what's the point of any appeal?
My lord, our primary position is that the appeal may indeed not have any point. That is why we have taken the primary position that it should not go forward at this point. It should await the outcome, at the very least, of the BVI proceedings.
Wait a moment. Whatever the outcome, just a moment. Whatever the outcome of the BVI proceedings or the Hong Kong proceedings, to which we'll come in a moment, the appeal has no point. The fact that either the liquidators or the receivers or both are those in control of the company is not going to be affected by whatever is decided in either the British Virgin Islands or in Hong Kong, is it?
My lord, that it may well be the case that the appeal is now being overtaken by events that have happened since we filed.
Right. Well, if that's sorry. Yeah.
Sorry, no, you finish, Christopher.
Well, I mean, if the appeal has in fact been overtaken by events which have happened, there's no point in it going ahead, is there?
My lord, I would be speaking without instructions, but I do see the point. I don't have instructions on submissions for that point. But I do see the validity of the point that is made.
Well, let's assume it's correct, and I can't for the moment see how it could be incorrect. If the position
Mr. President, can I come in there? Because I a question before you move on this point. Ms. Swirl, can you explain to me, if it was a creditor's petition on the basis of a non-disputed debt, I mean, is there any chance of the company paying off the debt, in which case it could be said that the question of the constitution of the board of the company would remain relevant? Or are you not in a position to answer that question?
My lady, there have been efforts to restructure the company's debts. I don't believe, and I don't have current instructions, I don't believe thus far the restructuring has been fruitful. But
I mean, one can imagine situations in which who was director of the company might matter. And maybe even in the terms of restructuring, it might matter. But I think in the light of the president's question, you need to explain that to us if that is indeed your submission. Thank you, President. I've concluded.
All right. Well, we seem to have got to the position that it seems highly likely, subject to the question as to whether or not there's any prospect of the debt being paid off, that this appeal has no point, because even if it were successful, the control of the company is now with the liquidators or the receivers or both. If that is correct, then if you need leave to appeal, the court would be likely to refuse it. If you don't need leave to appeal, it would mean that you're bringing an appeal as of right, prima facie, barren of practical purpose. Now, should the court allow that?
My lord, I am without instructions on the, or I had not considered and taken instructions on the utility of the appeal.
Really?
We addressed the reasons for the appeal, and it may be that I had expected that we were dealing with the listing of the appeal today and the directions.
Well, we are dealing with the listing of the appeal, if any, and the directions, but you've seen in the exchange with the respondents that they effectively say that the appeal has no point. I'm slightly surprised you haven't taken instructions on the question as to whether there's any point.
Well, my lord, I certainly can address the points that the respondents made. So the respondents, for example, say that so it says any order purporting to discharge or otherwise overturn the AGM order would serve no useful purpose in any event, since even if such relief were granted, the remaining portions of the orders which are not appealed against by the company would require both Mr. Tang and Mr. Chi to conduct the affairs of the company in accordance with the remaining paragraphs of the order. Now, that misses one of the key submissions, or one of the key arguments made by Mr. Chi and Mr. Tang, which is that the order was made in favor of parties who had not been validly appointed to Sinopoly and Union Grace. Now, I appreciate that that's referring back to the BVI proceedings, but there is a purpose in having this considered either by the BVI court or the Bermuda court. The Bermuda court would have made an order in favor of parties that were not validly appointed if the BVI proceedings are determined in our client's favor.
But that issue of the appointment of those persons is, as you concede, overtaken by events in relation to the company now being under the control of the liquidators and or receivers.
No, my lord. No, my lord. Those companies are BVI entities, Sinopoly and Union Grace. So the outcome of the BVI proceeding.
No, kinetic. We're concerned with kinetic. Kinetic is subject to liquidation and receivership.
Yes, my lord. Yes.
So, I mean, what happens in relation to Sinopoly for the moment is irrelevant. the reason why the proceedings would appear to be a waste of time is because control of the company has passed and will continue to pass from those who were once directors.
Yes, my lord, save that one of the receivers is one of the appellants.
Yes. So what?
So if the power of the company remains with, so if the receivers and if the receivers remain with the powers that they have to progress the appeal, then have matters been overtaken?
Well, yes, because if and insofar as the receivers don't have powers, then the liquidators do.
Yes, my lord. Yes, my lord. But my instructions are that that is not the case.
But yes, one of the receivers is the appellant. That means that he and his co-receivers and or the liquidator now control the company. That fact doesn't alter the logically prior fact that the fact that those two between them control the company means that the question as to whether or not the directors were validly appointed before the company went into liquidation is no longer relevant. The fact that he might have, that's the position.
Thank you, my lord.
Right. Well, what I'm, in light of where we've got to in relation to that, the following questions may not necessarily arise, but I want to make sure that I understand what the arguments are in relation to the BVI and the Hong Kong proceedings. As I understand it, what has happened is that the liquidators of FDG Electric, the ultimate parent company, who were appointed by the Bermuda Supreme Court originally in March, and then with full powers granted them in July 2020, and then the actual provisional liquidators were replaced on the 24th of July. So the provisional liquidators of FDG Electric caused FDG Electric to pass resolutions appointing Mr. Middleton and Mr. Lee as directors of Sinopoly and of Yang, if that's how you pronounce it, who between Yang owns Union Grace. Mr. Middleton and Mr. Lee caused Yang to appoint them as directors of Union Grace. So as a result of all that, the liquidators of Electric got the persons they wanted to be in control of Sinopoly, and those in charge of Sinopoly got Sinopoly to propose 4 candidates for the directorship of Kinetic, and caused Kinetic and they those in charge of Sinopoly brought the petition of Sinopoly in relation to the AGM. Is that right so far?
Yes, my lord.
Now, what is not entirely clear to me is why it is said that the liquidators are not entitled to do all this, given that they were given full powers by the Bermudian court. Is it firstly, I understand that there to be 2 points. Firstly, that the appointment by the liquidators of Electric of Mr. Middleton as a director of Sinopoly is said, and presumably Mr. Lee, is said to be invalid. Is that right?
Yes, correct.
And why is that?
My lord, in the BVI proceedings, the position is taken that the JPLs were not empowered under the order appointing them. So this is the JPLs of FDG Electric, that their powers did not extend to appointing directors over Sinopoly and Union Grace.
Why?
Um,
They were given full powers, as I understand it, by the Bermudan court.
My lord, may I have a moment?
Yeah, of course.
I'm looking for the relevant where we dealt with this. My lord, I'm going to need to, I've looked at our skeleton and I'm going to need to pull up the evidence filed in support. I'll be as quick as I can.
Where? So which skeleton?
I was looking at the submissions that we made before the lower court, before
Oh,
the
I
Supreme Court. Not a skeleton for this hearing, no.
No, there haven't been any.
No.
I mean, I'm slightly surprised as to whether this matter was considered before the Supreme Court, because at paragraph 52 of his judgment, the reasons given in July, Mr. Justice Muston said that due to the shortness of time available to the court queried Miss Dool about identifying what the issues were in respect of the 1st of April 21 order that would warrant further submissions on a hearing of the notice of motion. And he says that you identified a number of issues, one of which was as to paragraph 6, as to the standing of Mr. Middleton, including consideration of proceedings begun the very same morning in the British Virgin Islands for certain declarations about the majority shareholders in Mr. Middleton. In the light of that extremely brief reference to the BVI proceedings discussed that very morning, I rather question whether your submissions had anything about what was at stake and what the issues were in the BVI proceedings.
Yes, my lord, we didn't go into that in any depth. That was one of the reasons why the notice of motion for joinder was to be set down to be heard at another time. I just was checking whether that point was, whether what I'd like to put my hands on, and I need a moment to do that, but what I would like to find is why we say the order made appointing the JPLs in the FDG electric matter don't go far enough. Now, I don't know that we've addressed the court on that previously, but I wanted to see if it was addressed in our evidence.
Right. Well, at any rate, there was.
We don't act for any parties in FDG electric at present. And we were not present when the order appointing the JPLs was made. But I do believe that to be one of the critical elements in the BVI proceedings.
Right, so where we've got to is that for presently unknown reasons, it is said that the appointment by the liquidators of electric of Mr. Middleton and presumably Mr. Lee as directors of Sinopoly was invalid. Although the point can't have been, all that was said before Mr. Justice Muttenden was that an action had been begun that very morning in relation for certain declarations about majority shareholders and Mr. Middleton. Right, well, then the next thing which I understand is said is that Sinopoly and Union Grace were not entitled to exercise the voting powers that they had in Kinetic because the shares that they had in Kinetic were pledged to Sinopower. Is that what's said?
Yes, my lord.
And that is said to mean that the liquidators could not procure the exercise by those companies of their prima facie rights as shareholders in Kinetic. Now, as I understand it, this point was taken in the Hong Kong proceedings, which were launched by Kinetic on the 29th of April 2021, at a time when Kinetic was effectively under the control of Mr. Chi. Is that right?
Yes.
Right. Of course, what happened is that control of Kinetic changed on the 30th of April 2021, and it is now in liquidation. So are these Hong Kong proceedings going to get anywhere?
My lord, I believe in the Hong Kong proceedings, the confirmation of the appointment of the liquidators is the next step.
Isn't that normally done at the same time as the liquidation order is made? The JPLs typically become the liquidators at that point.
Well, at a meeting of creditors, there was a change of appointment. So my understanding is that that change of appointment now needs to be confirmed by the Hong Kong court.
Well, that may well be so, and I'm sure he's right, but that doesn't meet the point that I'm dealing with. If you look at the chronology of legal proceedings, it records on the 29th of April
Mhm.
that Kinetic filed an originating summons for a declaration that Sinopoly and Union Grace, as controlled by the FDG Electric joint provisional liquidators, are not entitled to exercise their rights and or powers as shareholders of FDG Kinetic. Although acting through Hong Kong solicitors, Sinopoly and Union Grace, as the defendants, refused to accept service of the originating summons. For FDG Kinetic, now in Hong Kong court compulsory liquidation, acting through the official receivers of Hong Kong or the liquidators, would need to make an application to the Hong Kong High Court to continue these proceedings. If leave to continue is granted, further applications are required for substituted service and or leave for service out of the jurisdiction of the proceedings on Sinopoly and Union Grace. So the Hong Kong proceedings have ground to a halt, and they can only move forward if Kinetic takes steps to seek substituted service or leave for service out of the jurisdiction on Sinopoly and Union Grace. And Kinetic shows no signs of doing so and is under the control of the receiver stroke liquidators.
That's accepted, my lord.
Right. So it looks as if the issue in the Hong Kong proceedings is never going to be resolved.
I don't disagree with that, my lord.
Right. Okay. So
It will never be resolved unless either the liquidators or the receivers take steps.
Yes. Well, the idea that the liquidators or receivers should take steps to determine whether their predecessors were in effect validly appointed is unreal, isn't it?
My lord, save for the fact that the BVI proceedings are continuing.
Sorry, that's the BVI proceedings. I'm afraid I like to take one thing at a time.
Yes, my lord, but the point I'm making is that the door is still partly open, I believe, in the Hong Kong proceedings for further steps to be taken once the court has confirmed the appointment of the liquidators.
Yes, but no doubt. But why on earth are the liquidators going to take steps to pursue an action that Sinopoly and Union Grace were not entitled to exercise their powers as shareholders of FDG Kinetic to appoint directors, when it must be a matter of supreme disinterest to the liquidators of Kinetic whether before they were appointed liquidators, the right directors were in place?
My lord, I simply make that point in case my instructions are correct, that it is the receivers who will be able to advance the Hong Kong proceedings rather than the liquidators.
Well, assume that. Assume that the receivers can advance the Hong Kong proceedings, and assume in your favor that it's the receivers who are in charge of the affairs of Kinetic as opposed to the liquidators. Why on earth should the receivers advance Hong Kong proceedings to deal with the position before the liquidation and in circumstances where it's the receivers who are in charge, whoever the directors were.
My lord, there may be scenarios where it would matter. For example, if the company was to emerge from the winding up proceedings, if a restructuring was to be got away, there may be scenarios in which the answer to that question would matter.
Right.
Can I just ask you about that, Ms. Will? If the restructuring is going ahead, do the directors of the company have a role to play in that restructuring? Are they currently having a role in that restructuring or attempted restructuring?
The appellants certainly have a role in that.
Yes.
And my understanding is that the negotiations have been between the appellant and those parties who appointed directors to the board at the 29th of April AGM, at the 30th of April AGM.
So that there might, in those circumstances, as you suggest, be a situation in which it was relevant to know who the directors were. If the
Yes.
company had
Yes,
to
my
be
lady,
bound under
submit-
Newhart principles
Yes,
in relation to any restructuring proposal.
yes, my lady, we submit that there could be scenarios under which this very question would be relevant.
Thank you.
Is Mr. Chi still a director of the company?
Yes, my lord.
He is. That's what I thought. Okay. Right. But what was going on in the Hong Kong proceedings? Was that raised before Mr. Justice Mussenden? I haven't found any reference to it in his judgment. And he was referred to the proceedings that began that day in BVI, because you referred it to him, as we've just seen. But I haven't picked up any reference to what was going on in Hong Kong. Right. Well, I'll assume it wasn't taken unless you can show me where it was. So going back to the BVI, the BVI court might, although it's not quite clear, not clear on what basis, decide that Sinopoly was not entitled. No, it might decide that Mr. Middleton was not an authorized director of Sinopoly. And if the court in the BVI did do that, as things stand, it looks highly likely, they're not absolutely certain, that the proceedings, the conclusion is barren of practical consequence. But in any event, if it were to be determined that Sinopoly could not validly have brought the petition because Mr. Middleton was not validly authorized to act for Sinopoly, then presumably you could apply to Mr. Justice Mussenden at an adjourned hearing of the petition to set aside, for what it's worth, the petition under the proceedings on the basis that they weren't validly brought by Sinopoly.
Yes, my lord.
Right. So I think the position that we've got to is that the appeal is highly likely to be barren of practical consequence. But on the off chance that the court in the British Virgin Islands might decide that Mr. Middleton wasn't validly appointed as a director of Sinopoly, you would have a remedy in the petition because you could go in front of Justice Mussenden and raise the point in front of him.
Yes, yes, my lord.
Right. Well, what should we do in those circumstances?
My lord, our position is that the appeal should be stayed pending the outcome in the BVI proceedings.
Right.
But on what basis? Bearing in mind the question that my lord just posed.
Well, on the basis that depending on the outcome of the BVI proceedings, there may be I mean, I just didn't want to close the door completely. If there was an outcome in the BVI proceedings, that would mean the appeal.
I thought we agreed that if there was a particular outcome in BVI, that would enable you to make an application to Mussenden J.
If my clients won their claim in the BVI.
Yeah.
Correct.
Yeah. So you've got a remedy. If you succeed in the BVI, you don't need to come to the Court of Appeal because you can say to Mr. Justice Mussenden, as it now turns out, the court which is relevant to decide has decided Mr. Middleton was not authorized on behalf of Sinopoly and the proceedings before you were invalid, and please set it all aside.
Thank you, my lord.
So what should we therefore do?
I don't have instructions to seek to withdraw I can take instructions.
Right. well, perhaps we better hear from Mr. Robinson. Thank you. Mr. Robinson.
Thank you very much, my lord. I should just say that Mr. Masters doesn't appear with me. I think Mr. Quillo announced his appearance, and I didn't want you to think that he was absent without leave. He did not intend to appear today.
That's fine.
My lord, if I could deal firstly, if it would be helpful with the issue of whether or not leave is required. And we say, my lord, that the test, the application, the well-known application test is whether or not the orders disposed, so the orders of the 1st of April and the 29th of April disposed of the case. And I submit, my lord, that the backwards and forwards this morning with Ms. Zool indicates, of course, that that's not the case, because the whole nature of the proceedings and the petition proceedings under Section 76 of the Companies Act, of course, is to regulate an AGM. And my client, the respondent, came to the court and said, please regulate the AGM. And so the substantial order was the 1st of April, but of course, that then set out a number of paragraphs with regards to the AGM, which didn't take place till the 30th of April, as the court knows. And so, my lord, even though the court did regulate the AGM on the 1st of April, the petition didn't come before the court on that date. The petition didn't come before the court, my lord, until the 9th of April.
Yes.
Sorry, my lord, that's not right. The petition was first returned for hearing on the 9th of April. Sorry, that is correct. And so, my lord, the petition was then adjourned for a number of times, and was adjourned and was also heard by the court on the 29th of April, and again adjourned, as the court knows, until the 6th of May, when it was then adjourned sine die. So the short point is that the court is supervising its orders to regulate the AGM. The petition comes after the first order, but then is adjourned effectively then until the 29th of April, and then adjourned till the 6th of May, so that the court still retained jurisdiction under these proceedings to deal with anything that happened on the 30th of April, being the AGM date. And so I submit, my lord, that none of those orders of the 1st of April or the 29th of April disposed of the case, because the court is making interlocutory orders, giving directions with regard to satisfying my client's application under Section 76. And so that's in substance, my lord, why we say that leave is required, because neither of those orders disposed of the case.
I see. They didn't. I mean, if the position is that the only thing that's outstanding is costs, you can't say there hasn't been a final order simply because the costs haven't been dealt with.
No, I would accept that.
What you say is that it was stood over in order that the court could deal with anything that arose on the 30th of April. It's now been stood over sine die. What was the footing on which that happened?
To be perfectly honest, I can't remember what happened on the 6th of May. I know, my lord, that on the 6th of May, of course, the AGM had taken place and the directors had been appointed. But I don't. I'm sorry, my lord, I don't recall.
But at any event, by not concluding matters, the court has left open the prospect of dealing with the position as to the directorship of the company in consequence of the AGM. And it transpires from what's happening in the BVI that it may be necessary for the court to continue to exercise those powers if it turns out that Mr. Middleton was never validly appointed a director of Sinopoly. Hello?
I think he's frozen.
Yes. Yeah. Can you hear me, Mr. Robinson?
He's dropped off the
Yeah.
call, so he may come back on.
Yes, yes.
My Lord President, while we're waiting for Mr. Robinson, is it possible for the justices to retire to chambers very quickly for an administrative matter to be raised?
Yes, it is. Mhm.
And we have Mr. Robinson back.
You're muted, Sir Christopher.
So sorry, my lords and my lady, I was kicked out, and I hope you can now hear me again.
Right. Right. I think we're now restored. Mr. Robinson, I don't know how much you heard of what I said before you froze, but I think I was. You hear me?
Yes, I can. I'm so sorry.
No. These things happen. What I was saying was that what I understood you to say was that although if the only question outstanding had been costs, that wouldn't mean that the judgment wasn't final. Nevertheless, what happened was that the petition was adjourned until the 6th of May and still stands adjourned. That enabled, and must have been intended to enable, the judge to deal with anything that in relation to the governance of the company that arose on or after the 30th of August. And in any event, in the events which have happened, it enables him, as part of the petition, to deal with anything that may arise in consequence of whatever decision is made in the British Virgin Islands.
Yes, no, that's completely correct. Mr. Justice Mussington dealt with that at paragraph 60 to 62 of his ruling. I don't think he said expressly that that was the basis of the adjournment application in those paragraphs, but that is in substance exactly what happened, which was that you'll see, my lord, if you have that judgment of paragraph 61, page 28, Mr. Justice Mussington records that I made submissions based on all of my previous submissions, leading to settling the AGM and its conduct. Third affidavit to Mr. Middleton, which was an updating affidavit to update the court. And then, my lord, he simply says in paragraph 62 that the petition was adjourned for further mention.
Yes.
So it was very clearly so effectively that the court could continue to supervise its previous orders regulating the AGM. It wasn't simply adjourned so that costs could be dealt with, and I'm sorry, I don't recall why on the 6th of May that was not dealt with.
Okay. So you say that leave is required, and I suspect you say that leave should be refused because, as matters stand, it's highly likely that the proceedings are barren of practical consequence. And even if that is not so, any problem that may arise as a result of the decision in the British Virgin Islands can be dealt with by Mr. Justice Mussington as and when, and there can then be, if necessary, an appeal to the court on that.
Yes, that's correct, Lord. That's exactly what I say. I mean, I don't, in respect to the BVI proceedings, I simply add that the issue which has been dealt with in the BVI proceedings was before Mr. Justice Mussington, and that was before Mr. Justice Mussington on the application of the company, because the company, while it did not appear at the hearing on the 30th of March or 1st of April, filed submissions with the court. And in those submissions, my lord, the company expressly took the point that they questioned Mr. Middleton's capacity to represent Sinopoly for the very reasons that you have been through this morning. So it's and you'll see, my lord, in Mr. Justice Mussington's judgment that he also deals with that point in the sense that he records that I dealt in some detail with the submissions that have been filed on behalf of the company.
Can you just show me in the judgment where he deals with, he does record what the company said, and it's rather a long judgment.
Yes, Lord, I had that. So you'll see, Lord, if you have a page 10, you'll see a paragraph 29, where he records that the company was not represented by counsel. Instead, it sent submissions by email to the court and to Sinopoly. And then he deals, my Lord, at paragraph 11 on page 32 with those submissions.
Sorry, paragraph 11.
Sorry, page 11, paragraph 32.
Yes. Oh, I see. Yes.
The key point is in paragraph 34, actually, which is in my reply submissions to the company submissions, page 14, paragraph 34B, if you have that.
Wait, that's a different point. There are two different points. Point number one is whether Mr. Middleton was validly appointed as a director of Sinopoly. Point number two is whether Sinopoly validly exercised its apparent shareholding rights in the company. 34B is dealing with point number two. There is at 36C.
34C.
There is no reference in the Middleton affidavits as to whether the purported appointment of Mr. Middleton as a director of Sinopoly has been duly approved by, that's the debenture holder, effectively.
Yes, Lord,
Yes.
that's...
Yes, I
yes.
follow. Yes, I see.
So the point I'm making is that the company did raise this, even though it wasn't represented. It was an inter-parties hearing that the company had filed written submissions. And in fact, my Lord, as you all see from Mr. Justice Mussenson's judgment, because that he didn't feel as if he had enough time to consider the company's written submissions and affidavit evidence, he adjourned the hearing till the following day, and he records in the hearing that he gave judgment the following day.
And did he deal with the question as to whether or not Mr. Middleton had been validly appointed when he looked at it the following day?
He didn't, my Lord. In paragraph 42 on page 23, you'll see he starts the heading, the 1st of April order. On the 1st of April, having read and considered more fully the company's submissions. He doesn't, I accept, my Lord, that in subparagraphs A to G, he doesn't deal with that issue in express terms. I would simply submit that implicitly in 42D, he said, I had accepted that Sinopoly had submitted to the company a nomination comprising names. He implicitly accepts, my Lord, on my submission that Sinopoly had standing, having considered the company's submission. I fully accept he doesn't go into that issue in detail in his ruling. But it would be wrong to suggest that that matter wasn't before the first instance judge, and therefore the issue of the BVI proceedings, which were issued on that 28th, I think, of April, while I accept, of course, that they seek to determine what they seek to determine, the issue is before the first instance judge. And in my submission, if Ms. Zuhl's clients were to be given leave to appeal, which I say they should not, then they would have to be seeking to adduce fresh evidence before the Court of Appeal as to whether or not the Court of Appeal would listen to further evidence as to BVI law effectively.
Well, yes. I mean, if it becomes relevant to know what the BVI law was about the validity of the appointment of Mr. Middleton as a director of Sinopoly, it would be necessary to have evidence about what the BVI law is, because it's not clear to me at the moment what is the basis upon which that's said, let alone whether it's correct, which might be thought to be another reason for refusing leave, so that if there's anything in this point, it can be raised, if necessary, following the decision of the BVI court, which will have made a decision either on evidence or without the need for evidence, because the BVI court doesn't need evidence of what the law of the BVI is.
Exactly, my lord. I fully accept that it could go back to Mr. Justice Mussington at first instance, should the BVI proceedings go in Mr. Chi's favour. It could go back to Mr. Justice Mussington on an application to set aside his orders, because the petitioning shareholder, as it turned out after the event, didn't have standing to do so. On that point, Lord, if it would be helpful, I could just deal with the issue of the FDG electric vehicles JPL appointment order, because of course there's two issues in the BVI proceedings. One is the allegation that the JPL appointment order of FDG electric vehicles did not give the JPLs the power to vote the shares, and then there's a separate BVI law issue. But
wait a moment. You say there are two issues in the BVI proceedings. I had understood that there weren't, that there was one issue in the BVI proceedings, namely whether Mr. Middleton was validly appointed as the director of Sinopoly, because if he wasn't, the whole of the exercise by Sinopoly was invalid. That's item number one, which is the subject of the BVI proceedings. But there's a second question, whether or not Sinopoly was able to exercise its voting rights, having regard that the fact that it had created a debenture in favor of Sinopar, and that issue was to be determined not in the BVI proceedings, but in the Hong Kong proceedings.
Yes, my lord, that's quite right. I simply was saying that, as I understand it, in the BVI proceedings, there's the issue of whether or not the Bermuda court's appointment order of the FDG electric vehicles liquidators was wide enough to give them share voting powers. There's also a separate issue of BVI law, as I understand it, but that's not related to this issue of whether or not the debenture holder had effectively taken away the right to vote the shares.
The references to whether the GPL order was wide enough to give the liquidators a power to appoint directors of Sinopoly. No, to appoint directors of no, sorry, I'm getting lost now. Yes, was to give the liquidators a power to appoint directors of Sinopoly. That arises in the BVI and the Hong Kong proceedings, does it?
No, my lord. The Hong Kong proceeding simply deal with the FDG Kinetic Limited seeks a declaration that Sinopoly and Union Grace are not entitled to vote at shareholders' meetings in general meetings of the place of vehicles. That's the relief which is sought on the BVI in the Hong Kong proceedings, my lord. Sorry.
Yes.
But,
yeah, quite right. I'm sorry.
So, my lord, I don't know whether it's helpful or not, but the only point I was going to make with regard to the Bermuda court's order appointing the liquidators of FTG electric vehicles, Ms. Zul says, and her client says that order was not wide enough to give the JPL's share voting power. I would simply say, my lord, that as you have described it to Ms. Zul, was a full powers order, and expressly records that the powers of the JPLs were not limited by Section 170 (3) of the Companies Act 1981, which is the standard form order when you're appointing full power JPL orders. I fully accept that order then recites a long list of powers, which I think the point taken against us is that there's no express the JPLs have a share voting power, but the point I'm making is that it's a full powers order, and it did not limit the powers of the JPLs pursuant to Section 170 (3) of the Companies Act 1981.
Well, sorry, what does that section say?
So, Lord, Section 173. Section 170 (3) says when the court appoints provisional liquidator, the court may limit his powers by the order appointing him.
Oh, I see.
And so limitation, he has the full powers.
Yeah. So what the JPL appointment order of FTG Electric Vehicles says is that the powers of the JPLs shall not be limited pursuant to Section 170 (3) by the order dated the 12th of March or otherwise, such powers to be exercised by the JPLs jointly and severally. And then it goes on, as these orders always, in my experience, do, my lord, to list a long number of powers, and without restricting the general of the grant of full powers to provide a long list of express powers. But the point I'm making, Lord, is that Section 170 (3) of the Companies Act says what I've just said, and the appointment order expressly says powers are not limited. So I think, Lord, that's the terrain upon which Ms. Zuhl's clients seek to challenge the scope of the JPL appointment power in respect of FTG electric vehicles. But I'm sorry, but if that's not, I'm not sure how helpful it is for the court.
Well, it's moderately helpful. I mean, all I've got at the moment in my mind is that the liquidators of electric vehicles were appointed with full powers, not limited in any way, in accordance with the Act. That would appear to suggest that the liquidators could pass resolutions appointing Mr. Middleton and Mr. Lee as directors of Sinopoly. And what I haven't understood is what the contrary argument is.
I think, Lord, the contrary argument is that in the order appointing the JPLs, even though it gives them full powers not restricted under 173, there's a long list of enumerated powers.
I see.
As I understand it, and the point is taken that it doesn't say in so many words they may vote the shares of underlying companies.
Oh, I see.
That's the point, I think, taken against that order, which Ms. Zuhl's clients take. But I submit, my lord, that there's nothing in that. It's that they had full powers just as you have described it. That was the purpose of the Supreme Court order.
Yes. Well.
But in any event, my lord, the point.
So you say the claim in the BVI doesn't sound very promising.
Well, I said BVI claim doesn't sound very promising, but even if it is promising, it doesn't give. It doesn't result in, first of all, the order being undermined because the issue was before the first instance judge. But secondly, of course, there is the remedy of applying to set it aside because the petition is still alive, on having been adjourned on the 6th of May, 2021.
But how can we possibly decide whether the BVI litigation has got any utility at this stage or any relevance? I mean,
no, I accept that
we've got very limited papers. We can't possibly do a proper analysis of that, can we?
No, I accept that, my lady.
Thank you.
Right. Is there anything else you wish to say?
My lord, well, the only other point which I wanted to pick up on, which may have gave assistance to the court, is that the Hong Kong winding up proceedings are exhibited to Ms. Zuhl's client's third affidavit and evidence. And the point was taken in our argument this morning as to what the nature of that winding up petition was. And I can give you the page reference. I don't know if you've got that in your papers.
We don't have a core bundle.
Because we don't have a core bundle, we have to flap around to find papers.
So tell us what the nature of the Hong Kong winding up proceedings is.
Well, it's a creditor's petition. That was the point. For your reference, it's page 554 to 564 of Mr. Chi's third affidavit exhibit, which is in support of his leave to appeal application. And the winding up petition was on the basis of insolvency of a debt of approximately 68 million Hong Kong dollars. That's on page 558. So that I simply draw attention to that, first of all, because it was raised this morning, but also because it rather indicates in my submission that the company was wound up on the basis of insolvency, and therefore the prospect of there being a phoenix from the ashes, as it were, and some utility then to the board having some residuary power. Now, I accept it hasn't been wound up in Bermuda. The board has a residuary power potentially to petition to wind it up on the grounds of insolvency in Bermuda, but beyond that, it's very difficult in my submission to see what utility there is in challenging a member's application under Section 76 to regulate the meeting.
But if the Hong Kong proceedings were ever to proceed, and if they were to say that Sinopoly was not entitled to exercise voting powers in Kinetic, and if that potentially made any difference, that again would be something that could be dealt with by Mr. Justice Mussenden.
Yes, that's right. I think perhaps talking across purposes, the winding up petition is the creditor's petition in Hong Kong, whereas the Hong Kong proceedings, I think, would only be able to be pursued by the company in winding up in the usual way if there's decided that they wish to pursue those proceedings.
Sorry, say this again more slowly. You broke up. The Hong Kong proceedings could only be pursued.
Well, so what I was taking, my lord, to a moment ago was the Hong Kong petition by the creditor, upon which the winding up order was made. But the issue of the Hong Kong proceedings, would only come back to life if the liquidators then decided there was utility in those proceedings in pursuing them in the name of the company in liquidation. Which I think, Lord, is the point you put to Ms. Zool, that for practical purposes, and I accept the court can't conclude this, but for practical purposes, the Hong Kong proceedings, which seek to challenge the votes at the AGM, for all practical purposes, will not proceed because the company is winding up.
I think she says the receivers could bring these proceedings.
Proceedings are simply to deal with who can vote at the general meeting of the company. Which is, I think that was my point.
Yes. But could the receivers procure Kinetic to continue with the Hong Kong proceedings?
My submission, they could not, because the receivers are receivers over the assets of the company. They don't have power to control the board. The board has lost its power. As a matter of Hong Kong law, the board has lost its power to manage the company. The receivers don't have the power to manage the company. The receivers have the power to take its assets and recover its assets to the benefit of the debenture.
Yeah.
Why do you say they don't have the power to exercise, to enter into contracts?
Because they've got no power to act in the name on behalf of the company.
Yes, but in the name of the company, they have the power to enter into contracts, don't they?
The receivers, my lady?
Receivers normally, but not always, have power to enter into contracts on behalf of the company if they're dealing with the assets over which they have been appointed receivers, or if they're, as we call them, administrative receivers. So I'm not understanding the point you're making, Mr. Robinson.
Well, the point I was making was that the receivers did not have the power and don't have the power to stand in the shoes of the shareholders at the general meeting, and nor do they have the powers of the directors. They've got the powers that are given to them as receivers pursuant to their debenture.
Well, that depends what their powers extend to.
It does. I accept that. It does.
Yeah.
Right.
I'm not sure, my lord, if I can be of further assistance to the
No.
court.
I think the court will break out for a moment. Right. Quayla, can you unmute me each time? For some reason, my unmute system doesn't operate. Material, is anything?
Muted.
Quaylo, can you hear me? Quaylo?
I can hear you.
Yes, I hear you.
Right. Material, is there anything you would like to say?
My lord, I just wanted to note, and this point may have already been taken into account, but my clients are not parties to the petition. I don't know that that would preclude them from being able to come back to the court and make submissions to Justice Mussenden in the event that they were successful in the BVI proceedings. But I did just want to note that they're not parties to the petition in the Supreme Court.
Well, what happened? They applied to be made respondents. What happened to that?
That application has not yet been heard.
I mean, it's bizarre. So how are you before us at all? If you weren't part of the proceedings below, how can you appeal to the proceeding of the court above?
We didn't appear on the petition. We were there on a watching brief. We appeared on the summons, on the hearing of the summons.
Sorry, the hearing of which summons?
Mr. Robinson's client filed both a summons and a petition. So the summons is what was heard first, as I understand it. We weren't present at those proceedings, but it's my understanding that it was the summons that was heard first. We're not a party to either, I should add. We applied to be joined to the proceedings.
Right. So,
and that application was not granted at that time, but the notice of motion was allowed to proceed in due course.
Sorry, if you appeal to be joined to the proceedings and haven't been joined, I repeat my question. You weren't party to the proceedings below. How can you appeal above?
Oh, because Mr. Chi and Mr. Tang have standing. They're interested in the appeals. They do have standing to appeal under the Court of Appeal rules.
I don't think that answers the President's question.
I thought the question was, how would we have standing to appeal?
Well, how do you have standing to appeal if you weren't party to anything below?
Mr. Chi and Mr. Tang are affected by the order that was made by the court, and therefore would have standing to appeal as interested parties.
I mean, it could be said that their personal rights were affected. Is that what you're saying?
Yes. Yes, my lady.
Well, in their capacity as shareholders or directors?
In their capacity as bound by the 1st of April order.
Right.
Right. Thank you. Well, what we propose to do is as follows. We are of the view that leave is needed for this appeal to go forward. What we propose to do is to adjourn the application for leave and to direct that it is only to be renewed after the decision of the court in the British Virgin Islands. And on renewal, there will need to be filed an affidavit which gives evidence of what has occurred in the BVI proceedings and sets out such reasons as the would-be appellants rely on in support of the proposition that there is some utility in an appeal in the events which have happened. We take that stance rather than refusing leave now, because although it seems to us highly likely that an appeal is barren of practical consequence, we cannot rule out the possibility that the decision made in the BVI will affect the validity of the petition before Mr. Justice Mussenden. And although Mr. Justice Mussenden might be able to deal with that on a resumed hearing of the petition, it is debatable whether he can or should do so in circumstances where he has already actually decided, in effect, that the petition was validly constituted. Accordingly, those are the orders that we shall make. Subject to any arguments to the contrary, we propose to reserve the costs of this application.
Thank you, my lord.
Thank you, my lord.
We're grateful to the parties for their submissions.
Thank you. The parties may leave the room and the justices can remain.
Thank you, my lord. Good morning.
My lord and my lady.